Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about the written discovery phase of litigation. Written discovery is the way that attorneys find out what the other side's position is on why they're denying certain allegations in the complaint, or what information that they have or documents that they have that may not be available to our clients at the outset of litigation. So there's four main documents that we use in written discovery: interrogatories, requests for production, requests to admit facts, and subpoenas. Interrogatories are written questions to the other side that the other side has to answer in writing. Included in written interrogatories are things like, what witnesses are you going to call at trial? Why did you deny certain allegations of the complaint, and what's your position? And also specific targeted requests for information that is in the other side's possession. When they get written interrogatories, they either have to object to the interrogatory or answer the interrogatory fully in writing. The second document is a request for production of documents. So this is a request for the other side to produce documents to us that are in their possession but aren't in ours. And we list usually 30 or so, depending on the case, targeted requests for specific documents, and they have to either, again, object or provide those documents. The third tool in written discovery is request to admit facts. So a request to admit, the purpose of that document is to winnow down the issues that have to be litigated at trial. So if we think we're all in agreement that certain facts are true, if we issue a request to admit, we say, please admit that such and such fact is true. The other side either has to admit or deny the fact, and if they fail to admit or deny the fact within a certain time period, the fact is deemed admitted, and our case is basically proven. But if they, typically, it's for foundational issues, things that we all agree on. We want them to admit it so that we don't have to prove it at trial. Sometimes attorneys can get tricky with this and try to lay out all of the issues in the case to admit or deny, and then hope that the other side won't respond in time. And if they don't respond in time, that's a really easy way to win your case, because all of those facts are deemed admitted. The fourth tool is a subpoena, and a subpoena is like a request for production of documents or interrogatories. It's a written request to someone who isn't a party to the case. So interrogatories, request to admit, and production of document requests, those are all issued to the other side in the case. A subpoena is issued to a third party. So some third party has either information or documents that we need, and we issue that subpoena, and they're ordered by the court to provide those documents. Now, one of the reasons that lawsuits can take a while is that most of the time, from the time you file a complaint until you get to trial, is spent on arguing about written discovery. So if we issue interrogatories and the answers are incomplete, then we have to work with the other side to compel them to give us complete answers. If after working with them and sending something called a 201K letter, a letter demanding more complete responses, if we can't come to an agreement that the answers are complete, then we have to go into court and file a motion to compel them to answer those questions. And if we're forced to go that far in a case, then sometimes we can get sanctions and get our attorney's fees that we've spent trying to get that information paid by the other side. Subpoenas are similar. When you issue a subpoena, you have to give the other side the opportunity to object to it first, to say that, it's improper if they believe it's improper, and if we can't agree, we bring it to a court. So a lot of what happens in litigation is arguing about whether objections to written discovery are valid, and letting the court decide what needs to be presented to us, or whether the answers to written discovery are complete. And sometimes you have to chase the other side around if they're not responding in time, and we sent the letter saying they haven't responded in time. Sometimes we have to go to court to compel the responses in the first place. So that's why litigation can take a while, is because you need to get this information before you can move on to the next phase of litigation, which is the oral discovery phase, meaning depositions. Once you've completed written discovery, you've got the tools at your disposal to take someone's deposition. And if you think they're lying at the deposition, you can present the documents that have been provided by the other side in response to your production request, or present the interrogatories that have been provided to the other side, and you can ask them in the deposition, you're saying this now, but in your interrogatories you said something different. Are you lying now, or were you lying then? And once we've done the written discovery and the oral discovery, we've got a pretty good idea of what evidence the other side is going to present at trial and what the witnesses are going to say, so we're not surprised when we're interrogating a witness at trial. So in future episodes, we'll talk more about the oral discovery phase of litigation, the pleading phase, which comes before written discovery, and trial prep. If you want to learn more about either the litigation process or any of the other areas of law we practice, you can check out learnaboutlaw.com. It's got hyphens between all the words, so it's learn-about-law.com. We've got episodes on all sorts of different subjects, both video, audio, and we also have blog articles, so please check it out. Thanks.